All right, this is the September 8th meeting of the Habeas Standards Work Group. And welcome everybody. Thank you for being here. We're going to get started by taking a look at the draft that we've been working on for the last meeting or two. We went through the role of the attorney last time, and into your track changes for a minute. Into the education section, we removed the references to the 1983 statutes, tacked in the if available language for the professional listservs, and added this bit for representing youth. So I think that covers all of the things I said after the last meeting that I would edit and change after the meeting, and takes us into we talked about the workload stuff, so I think that takes us into the obligations of counsel at appointment. Before we get into the standard 2.1 stuff, does anybody have anything they want to cover on any of the standard 1 language? Okay. The standard 2, obligations of counsel at appointment. So I think we've talked about lawyers being appointed post initial filings. I don't know how long after the initial filings it generally takes for y'all to get appointed.
It can take a bit. It can take a month to 2 months. And some habeas clients are on the unrepresented list too, I found.
Okay. Do we want to include anything about length of time, or does this, do your obligations at appointment change based on the length of time it's been since the petition was filed? Tara's shaking her head.
I would say the immediacy for records is the main thing, that you want to get on getting the records as soon as possible. So you want to get a release of information as soon as possible, and talk to the client as soon as possible, and the rest of the stuff can kind of come in later.
Okay. So do we think this is good? Be familiar with the timelines regarding the amended petition and proceeding with the habeas case and immediate remedies. We'll get to the, requesting documents and having the client sign the ROIs at the next section. Actually, maybe this should be in the next section also. Sorry. Note to self. Okay. And then these, I think I pulled from largely from Tara's instructions as best practices for what to do kind of right after you're appointed. Any comments on any of these 1 through 5?
I have a question.
Sure.
And I apologize, since I wasn't here at the last one, maybe this was addressed. So with regard to number 5,
Mhm.
I'm just curious, is there a reason why we're calling the person the defendant?
Um,
Oh, yeah,
Is
that's right.
this like, are we talking about
Yes.
in a criminal procedure for number 5?
yes,
Because-
there's a reason why we're calling them the defendant. No, it's not a particularly good reason. I mean, the
Okay.
reason is that I did criminal work, and when I was writing these, that's my default thing,
Okay.
and it should be corrected.
Okay,
So
okay,
thank you,
so,
Ginger.
yeah, sure. I
Plaintiff.
just,
Plaintiff, not petitioner.
There we go. If you guys see that anywhere else, feel free to flag it or call it out.
Were you done, Ginger, in this section? Because
Yeah,
now
that- yeah, that was the
Okay.
only thing that I saw.
there isn't a right to counsel in habeas, so I would take out A, it's permissive. And B looks like it's straight out of a criminal context, so I would take that out too, because it's going to be
Mhm.
confusing. But there is a right to immediate judicial scrutiny.
I have a question. Is there a statutory right in Oregon for habeas counsel? I think
There is.
Well, yeah,
Um,
it's implied,
So I
but it's
don't know.
discretionary. It's discretionary though. It's
Okay,
not required.
okay.
Assuming that I can spell statutory right. Is that accurate? You have a statutory right to request counsel, and it's the court's discretion whether or not to grant it.
Yeah.
Okay.
So yeah, generally that won't be. I don't know how
Of course,
relevant
if
that
you're already appointed.
Yeah.
you're appointed, yeah.
Yeah.
Well,
I
I
would
guess,
add-
oh,
Hmm.
go ahead.
I would just, did you just take that out on purpose?
Yes.
Oh,
Do
okay.
you want to leave it?
I think you should, and add what you
Okay.
just said, which is, and it's the court's discretion whether to appoint. I think that's good information for folks to have, because nobody knows that.
Yeah, that's true. And they do have a right to a decision on the motion to appoint. For what that's worth.
Okay.
And then just in terms of like grammatical consistency, are you normally putting a semicolon after a colon, or are you normally putting a period?
It should be a semicolon in the drafting
Okay.
phase. I will
Okay,
bounce back and forth, and then that all gets fixed in post.
okay, okay. Not to be nitpicking.
No,
And
no.
I'm not good
Please
with rules
pick-
of grammar, so I don't know.
Pick all the nits you need to in
Okay.
this. Yeah. So is it a hearing or a trial that they have a right to expedite? Or
It's the
just
same, it's a trial, but it's also called a evidentiary hearing. It's technically called an evidentiary hearing, but you could say / trial, because that's more clear to most people what that is.
got it.
And I think to court staff, I remember going around and around about trying to set a hearing, and they were not understanding that I was talking about
Yeah.
a trial. You know, it was, anyways, I like the / idea.
Mm. Okay. Dates for upcoming appearances. How's that sound? Just tacking on and the ability to expedite expedite proceedings to things the lawyer needs to be familiar with and advise client of. In number 4. All good?
Yeah,
Mhm.
I would just leave it at a lawyer should be familiar with local practice.
So just after that.
Yeah,
Mhm.
and it's true. I never look at local practice, and I get burned.
Can I just read the whole thing before you take it out?
Of course.
Can you just say, like, including case docketing instead of regarding?
Like that?
Yeah, I don't know. I'm a little bit,
Yeah.
the thing that I think is important, but I know that we can't encapsulate every single scenario, is that I think it's important for clients to know that, there are lots of instances where they might not be transported for actual court appearance.
Mm-hmm.
But again, maybe that's just trying to incorporate too much
For my
into this
cases, my
document.
clients, oh, I'm sorry. Excuse me.
Go ahead.
My clients are never transported for any ever. I would hate it if they were. I think the only place where it sometimes comes up is Coffee Creek, but even still, I argue for them not to be transported because it's so disruptive.
Yeah, and so when it says the dates for upcoming court appearances, I'm just worried that if a brand new attorney to habeas has read this, that maybe they would think that, I don't know, does that read like the client will be at court appearances?
Kind of.
Why don't we do this? We can, when we're talking about client contact and communication, we can add a best practice for discussing transportation to hearings with clients, because I think you're right. I think there's more that goes into that decision than most people would think.
Yeah, so maybe go back up to what we were working on.
So we were here.
Okay. So may inform the client regarding expected case events and the ability to expedite proceedings.
Mm-hmm.
Or just take it all out, like Tara was saying.
Mm-hmm.
I don't have a preference.
I like your suggestion of using the word including. I think having some specifics to give people an idea of what we're talking about they should be familiar with.
Do local practice, including case docketing and processing, comma, court appearances, comma, and the dates for, so just a list so that it doesn't say, yeah.
Good catch. There we go.
Yeah.
Okay. Anything else in this section?
I think I would add after to expedite the proceedings under this a cite for unnecessary rigor, or immediate judicial scrutiny. So it's specific.
Okay.
I can give you the site if you want it.
Oh, if you've got it off the top of your head, that's great.
No, it's just post-it noted here so I don't forget. It's ORS 34.362.
There we go. Okay. Great. And if you had said you knew that off the top of your head and read it off the post-it note, I'd have believed you. Just, you know.
I don't remember numbers and cases. It's all going to be written down.
Same. All right. So client communication and client contact. We've got should conduct an interview with the client as soon as practicable after appointment and maintain regular contact with the client in order to explain the nature of the proceedings, meet client needs, obtain necessary information, consult with client about decisions affecting the course of the, shouldn't say defense. Litigation, conduct conflict check and respond to requests from client for information or assistance. Initial client interviews should be conducted within 7 days. And yeah. So let's start with the 7-day piece. Is that a reasonable time frame? Too long, too short?
I think it's a good time frame.
Okay.
My only concern is that, you know, if scheduling is working perfectly, then I think it's great. If scheduling within the institutions isn't, then I think 7 days might be difficult to me.
Mm-hmm.
But is this a situation where, you know, if that didn't happen, it came to OPDC's attention, then the attorney would just explain why it didn't happen that way? Okay.
Yep. Yep.
Okay.
I mean, what I envision would be someone says, my attorney saw me on day 9, and we would say, okay, attorney, this person says you didn't see them within 7 days. Can you provide a response? The attorney would say, well, I was in a 2-week trial and I saw them as soon as I could, given the trial schedule. And we would say, okay.
All right. Sounds good.
Okay. So then I think we have this comment addressed later on when we talk about amended petitions. But we may want to tack in amending the petition to something the attorney talks about in the initial meeting.
I do that
Okay.
because it always needs to be amended.
Okay. I guess anything else here in the bold that we need to cover before we drop down to the not bolded section?
Looks good.
Okay. All right. So let's take the best practices, and these are the more aspirational things that people ought to consider doing in every case, but may not be able to. And so, clear explanation and developmentally appropriate language. Use an interpreter if you need to. And then you're discussing that. So I'm assuming nobody has issues with using interpreters and using appropriate language to discuss with clients, but is there anything in that highlighted section that we need to worry about?
You want to change in the defense of the case to like
Yes, I
in the
do.
litigation of the case.
Anything else?
I feel like that first sentence,
Mm-hmm.
I don't feel like that's aspirational.
Okay.
I mean, I don't know, isn't it? I just feel like it's required that if you need an interpreter in a habeas case, that's not best practices, in my opinion. That just seems like
True.
a
Yeah.
standard. So that, however you want to word it, but that could just go after, go down a little bit. That could go after, no, up to the bold.
Oh, sorry.
What if you
Up,
just
not down.
put something like that? A lawyer must conduct a client interview. Well, I
Yeah,
was gonna say you could put
I'll
it in after that, but that needs to be a standard, in my opinion.
okay.
Yeah. That is a legal standard.
Yeah.
You have to.
Yeah, it is.
Yeah.
Yep. Okay. I'll move that up.
Okay.
We don't need to spend a bunch of time
Okay,
watching
that
me
sounds good.
figure
Cut
out
and
where to
paste.
put that.
Mhm.
But I agree with you. And then we can leave the what the lawyer should discuss.
Yeah.
Here, and fix that language so it makes sense without that first phrase. I know that oftentimes the people in habeas cases are incarcerated around the state.
They're always
Should-
incarcerated, actually.
Okay. I wanted to say always, but then I hedged.
I personally,
Do
I
you all
can't
do in-person meetings?
No. I mean, unless it's something on occasion, but like if you're being paid like $5 an hour, which we are, you can't go across the state where most of the cases are, which is on the eastern side of the state. It's just not possible.
Mhm.
I would say 95% of my client contact is by phone.
Okay.
And I try to see them like once in the life of the case if they're in a closer county.
Anybody else? Thoughts, opinions, agreements, disagreements?
I agree with that. And I thought that we addressed this issue when we were talking about, well, in the post-conviction, and I can't remember what language we came up.
Mm.
I think you're right, Ginger, but I don't remember either.
I also think you're right, and I can look it
feel
up.
like we said that clients should be seen once, or maybe like clients should be seen based on their needs, something like that. I would be interested to see what we said in the post-convictions.
I thought we were referencing like trial prep, getting ready for trial.
I'm sorry, I just can't remember.
That's all right.
That might be right.
So what we
Preparing
have in the post convictions, if a client requests in-person contact, counsels should make reasonable efforts to accommodate that request. Meet the person at least once before filing the amended petition. Meet in person at least, or meet in person as needed to prepare the client for trial testimony, and client management.
I like that language. We could maybe take out the second sentence that says meet at least once before filing the petitions.
Okay.
I disagree with that, respectfully, because one, it's just not actually essential to representation. What you have are the medical records and the medical claims. And if I too, ORCP right now is trying to get out of paying us more than $50 an hour for travel. If I had to travel across state to Malheur County or Umatilla, I could not do the work I do. I couldn't take the number of cases I take. And I don't think it's essential to, I mean, I think it's nice if you can do it just for connection. But in terms of like information that you get from the client, there's nothing that can, unless the client had like a disability, had a hearing, you know, whatever, some kind of cognitive disability where you really did need to be in person. I don't think it should be a requirement. I think it should be an aspiration if you can. But I mean, it's like 8 hours one way to Malheur.
We are
Yeah, I mean-
we are discussing aspirations now.
Yeah, that was my
Oh, okay.
understanding.
Okay.
What if we made the first, like a best
Mm-hmm.
practice and then leave out the other two?
I'm on board with leaving up B for sure. But I don't mind C because it just says meet in person as needed
That's
to
fine.
prepare. So if
Yeah.
if
Yeah, that's
A
fine.
is aspirational and B not needed, I think that gives
I agree.
enough, you know, wiggle room. But definitely take out B.
All right, there we go. All right, how does that read?
Looks good.
Okay. Moving on to number 3, the initial meeting. Review the initial petition filed by the client. Be prepared to discuss necessary elements of habeas. Procedure the client will be facing in subsequent appearances. Possible remedies if the client prevails. And should inquire if the client has any immediate needs regarding securing evidence or obtaining interim relief. That all sound reasonable to do
Looks great.
at the first
Yeah.
meeting?
Yep.
At the initial meeting, well, I guess we're not doing the initial meeting in person. This one might be a little tricky.
I just, as soon as I get a case, I send the release and an opening letter.
Okay, so what if we moved this one up to the obligations and appointment?
Yeah, and I think you could leave it and just say
Oops.
should discuss the importance of signing and returning the releases.
I have something to add once you're. I don't use typically the Department of Justice releases because I don't trust them, and they've they've done some super sneaky shit using their releases, like having witnesses access medical records who don't have authority to through Epic and cite the release. So after that happened a few years ago, Epic is a all hospital medical records kind of database all across the country. So I have my own release that I send, and it's modeled basically on the DOJ, but it has some additional language about protective language, and I'm happy to, like, if anybody wants that, send it out as a template.
Okay. So why don't we
Jordan,
just,
Are there
Go
going to
ahead,
be
Ginger.
forms attached to these standards?
that is not the plan currently.
Okay,
I think what we may do, if there are forms that need to be attached to anything, we may end up attaching them when we get to training standards and just creating trainings on how to use forms or what forms to use and then distributing them that way, which is probably a little ways out. So
And another issue
why
with
don't
the
we just,
oh, sorry.
I would just say, why don't we just trash the reference to the Department of Justice releases and just say, have clients sign releases to get medical information or other needed information early in the case.
That seems good.
Um, this bit, attorney should consider having records released to the client for the sake of expedience.
No, I wouldn't never do that. You'll
No.
never see them. They're in prison,
Yeah.
and it'll take 500 years. You want them to come to your office.
Okay. So we will just take that out and let's move back down. Lawyer should discuss the need for ROIs. I'm sure the client has signed and return them. That
well, I
work?
mean, that's not going to happen within the 7 days if that's what we're talking about, but
What's not?
they're not going to have gotten the releases, signed them, and return them within 7 days of appointment.
I think it's just send them within
In general, okay.
initial
Yeah.
stages. That's the way I read
Okay.
it.
Okay,
Yeah. So send them an appointment and then discuss them.
Can you just change it to assure the client signs and returns them?
yes.
Yeah.
Just make it present.
Boom. There we go. Okay. This may also need to be bumped up to the obligations and appointment. I don't know that that's exactly client communication related. But before we just move it up, does anybody have any issue with this one?
I don't.
Looks good.
So let's.
And I'm going to need to sign off like at 1:50.
No worries. Let's see. I think we are almost through. Well, we're about halfway through this section. So let's see. For number 5, things lawyers need to deal with before any of the meetings with clients. Anything to add or subtract from that list? Or edit, I suppose.
I would add consider medical and other experts. Begin considering experts.
Okay. I think we do have, scroll through this real quick, a black letter standard just lawyers should immediately and continually evaluate the need for experts.
Maybe it doesn't go there, actually, now that I think about
I
it.
feel like this is kind of a weird section.
The be familiar
that?
with before all the meetings section, or the other one?
Yeah, 5 just seems odd to me. But
How so?
I'm not saying it's wrong. It just, to me, that, I don't know, that seems like what you do at the initial meeting.
Mhm.
I don't know. It just seems kind of weird, but
It does seem to be kind of repeating the obligations of counsel, or maybe just things from other standards put into this one.
yeah. And that,
Okay.
I don't know. Just seems weird that you would do all those things prior to every meeting if you're just calling about one specific thing, but I don't know that it's worth trying to make it make sense, I guess. I don't know,
Okay.
Tara, what do you think?
I'd see what you're saying. I don't know that it's necessary. These are all things that you need to know throughout the life of the case.
Yeah, exactly.
So, I mean, these are kind of part of the standards and then also part of the talk to the client. You should always be familiar with habeas if you have a habeas, stuff like that.
But they all seem like
Okay.
things that should be covered somewhere.
So I will
Uh,
make sure
yeah.
they are all things covered in other sections and then delete that
Cool.
reference.
Yeah, it just seemed redundant.
Okay. Um, things to cover with client during the initial interview. Oh. I guess before I make sure those are all in there somewhere, is emergency release the correct term here? Is there
No,
some remedy for
isn't.
that?
There isn't really emergency release. I mean, the whole thing is built on release if you prove your case, but that never happens like before trial, and lots of contempt.
Yeah. And
So-
it does,
Got it.
and like we were talking about before, where it says if a client is in custody,
Mm-hmm.
Right.
that doesn't really make sense in this context.
Yeah.
Okay. I'm just gonna note that that's not a thing that needs to go somewhere else. Okay. So, these are all kind of things that I pulled from my experience, which is not habeas experience,
Yeah.
of things that I think you would want at the initial meeting. But feel free to tell me some of these aren't applicable. Most of these aren't applicable. There are other things you want.
1 and 5 seem odd. One seems like a release type information.
Mm-hmm.
But I do think it's important to understand that type of information, maybe more, I don't know, just like about their family, things like that. But I don't know really about the ties to the community piece and how long they've lived in their. I mean, it is interesting how long, or it is helpful to know how long they've been in like their current institution. I feel like institutional history is more important than community information.
How about that?
Yeah. Then
That
I think
better?
we should have a part in there about, we do want to know about like the family history of mental health, health conditions, things like that. Okay, I gotta run, but like I said, number 5 seems odd to me.
Okay.
I'll let you guys figure that piece out. So sorry, I gotta go. Good luck. Bye.
Good luck, Ginger. Thank you.
Yeah, I agree with 5. It isn't, I don't see that it is. I mean, we just like, what's really nice about habeas practice is you really don't need to know what their criminal history is. And you don't need to be, you don't even need to know what they're in on, except for that it's a long or short sentence and when they're going to be released. I would put in here, instead of past criminal record, when they believe they're going to be released, how long they've been in custody, and if they're eligible for any kind of trans leave, because that affects your case. Because when they're released, technically their habeas is over. Except when you have Geyer, who ordered some remedies to occur in the community, bitches. Ooh, that was recorded, sorry.
Sounds like a big win, so well done.
Sorry. I feel like that's going to come back to me.
So we have then the back to number 1, and then we'll jump back to number 5. Are there anything else related to like client's condition or client's history that you'd want to know?
Like
History
disciplinary
within the institution,
history? Is that,
disciplinary history.
you know, if that's how relevant that is, but sometimes potentially.
Mm-hmm.
Okay. Anything else?
I don't know how military service records would be. It could come up. I guess that could come up, actually. You could just, never mind. That's come up in one case of mine.
Okay. We've moved, well, say, current physical and mental health concerns. Do you want the educational records ever?
Mm. Can't think when
Not
that's
worth
ever
having in
come
here.
up. Yeah.
Immediate medical needs.
Sure. For sure.
Then we've got expected release date, length of time in custody, and eligibility for early release.
Mm-hmm.
Anything else under that that we need to add?
You can take out 6, I think. Financial conditions of release.
Okay.
I'm not sure how 6 would, but it can be helpful to have family members too. Sometimes they can give you records or background.
Mhm.
That could stay. It's useful.
Okay. And then anything that you all want to tell people at the first meeting just to make sure that they know and are aware.
Don't tell anyone that your lawyer said blah, blah, blah. It will, and everything you say is going to be part of your case now. Everything you say to any staff member is now going to be part of your case and most likely used against you. So be careful.
I'll probably want to reword that, but it's the idea. Um, Anything else in that section to add?
Do you tell clients, Ed and Tara, do you guys tell clients once you started a case, anything about like continuing to like file kites or keep record about any additional like requests for care or symptoms and that kind of thing?
Yeah,
Yeah, I would include that.
it's a first conversation.
Like that?
It's also kind of like making records by filing kites, as well as keeping records of like what you tell, but it's helpful to have that, certainly for appeal, it's helpful to have like a written official record.
How's that?
Yeah,
Mhm.
looks good.
Okay. So I am going to put in a big blue highlight here so that we know where we stopped. And we can pick up from here next time. Anybody have anything they want to cover in the next, say, 3 minutes before we adjourn?
Thanks for all the work.
Yeah.
No, thank you guys. I
It's great.
It's great.
could not have done this nearly as well without you, as you have seen by my attempt at doing it. So I really do appreciate all the work you all are putting into this. And we will
Good to see you all.
see you all in
Thanks.
2 weeks.
Yeah, good to see y'all.
Yeah, good to see y'all.
Bye.
Nice.
Bye.